wait for some time for everyone to join. Sorry for the delay. We had some technical difficulties. Even though we've been using Zoom for how many months, Ljubica?
Many, many, many months. Pre-COVID even, but there's always something.
So thank you for everyone for joining us. Like I said, we're just going to give everyone a few minutes to sign in, and feel free to say hello using the chat function. If you have questions, feel free. Keep my chat box open right here.
I'm just going to say, if anyone has any questions while we are presenting, feel free to put them in the chat. We are happy to answer questions as we go along as well. They're usually pertinent to what we're talking about. So.
And we are recording today's session, which will be posted online, and we'll send the link out to anyone who isn't available, or if you wanted to send it to someone else, but we're not making anyone show up on video. So feel free to use the chat function. So before we get into the presentation, Ljubica and I, we wanted to just go over some of the updates that have been happening as a result of some of the changes to the law in Ontario, specifically the law, well, the Employment Standards Act and the other act related to poppies. So Ljubica, have there been any COVID updates since we've last had a webinar?
So far, I think there are a few restrictions that have been lifted in terms of capacity limits. In terms of employment law, the law kind of remains the same, that employers across Ontario need to have vaccination policies. It's just what is contained in those policies might differ from employer to employer. So nothing much new in relation to COVID as it pertains to employers. But there are a few health and safety things that are happening. I heard on the radio this morning coming into work that booster shots are going to be more widely available. An announcement is set to be made at 1 o'clock today, I believe.
Yeah, so it's changing all the time.
Absolutely.
In terms of the news changes to the employment standards updates, there have been several changes that were unexpected, but the government says they'll be made into law. So specifically, the Employment Standards Act is going to be updated to prohibit non-compete agreements and to force employers to have a written policy on the right to disconnect. So to be really brief, a prohibition on non-competition agreements, the law right now as it's drafted, it will be pretty clear, such that any non-compete agreement would be void and unenforceable. There will be one exception written into the law related to non-competes after a sale of a business, and those types of non-competes would be permitted. And of course, if it's a permissible non-compete, it still has to be reasonable in terms of the time, the geography, the restrictions themselves. And once the law, and this applies to the right to disconnect as well, once the laws are finally passed into law and they receive royal assent and the regulations are updated, we may have a better idea of all of the different exceptions to the law. So the right to disconnect, to be brief, like I said, it will force employers to have a written policy that says employees are not required to answer emails or take phone calls after their workday is done. It doesn't really apply to on-call workers. If a worker is on call, they're being paid, and thus they are paid to connect to work. But like I said, we don't know all of the exceptions to that law yet. As lawyers, we're exempt from many different employment standards in Ontario, but we don't quite know yet if lawyers will be exempt, or other different professions, dentists or doctors or healthcare workers, all different types. There are a lot of different exemptions in the law. So we are waiting to see the changes to the regulations. With regards to poppies in the workplace, the government has stated they will pass a law to permit any employee to wear a poppy in the workplace. That's something they had mentioned they would do in 2020, but that law hadn't been passed yet. And what happened with minimum wage this week, Ljubica?
Well, minimum wage was raised this week, or it was announced this week. It will be raised in January to $15 an hour for regular workers, and there's also an increase for hospitality workers as well, because they get a lower wage based on the fact that they get tips and gratuities. So their wage was increased a little bit as well. And that will come into effect in January.
Right. And like I said, all of these changes, they haven't actually been passed into law yet. So they're all proposed, but with a majority government, I'm sure the government will not have a problem to pass those. There have been some new cases, but in the interests of time, I'd like to get started into the presentation. So thank you everyone for joining us today. We're going to be talking about two areas of the law. They're not really related to COVID, but they could be related to COVID. I think it's good to speak about things that aren't COVID related. So I'm going to be speaking about workplace investigations and the tips and tricks for employers to keep in mind. And Ljubica will be talking about termination without notice, or what we also call termination for cause, but we try not to call it termination for cause anymore. And just some reminders for employers if you're considering terminating an employee without notice or for cause. And of course, if you have any questions, feel free to put them in the chat. I have them on my other screen here. You can use the question and answer as well. And we'll get to all of your questions at the end. And we've saved time at the end for any questions related to these topics or any other topic that you'd like to ask about. So, sorry. So we're going to talk about workplace investigations. So generally, workplace investigations, there is no set length or size of a workplace investigation. A workplace investigation can be 30 minutes. A workplace investigation may take months. And it's all dependent on the circumstances. And so the reasons that an employer would be required or may want to complete a workplace investigation, I've set out, probably the majority of the reasons why an employer would want to complete a workplace investigation. Of course, workplace harassment, workplace violence, those are mandatory under the Occupational Health and Safety Act, those workplace investigations. And not only that, there are policies that must be in place and programs that must be followed by every employer in Ontario related to workplace harassment and workplace violence. But some other reasons why an employer may need to investigate issues related to discrimination in the employment context, but also in the pre-employment context. There may be, in a job ad or providing accessibility or accommodation to an employee, a prospective employee, if that person has a concern or a complaint, an employer may need to investigate those complaints. Of course, minimum standards, anything related to the Employment Standards Act or Canada Labour Code, breaks or time between shifts or vacation, for example, they could all be investigated. Unsafe work, of course, employees in Ontario have the right to refuse unsafe work, but what is unsafe work requires an investigation. And if that workplace investigation is not sufficient for the employee can go to the Ministry of Labor and ask them to do an investigation, which is probably based on what the employer's investigation was. So that's always important to keep in mind. Any misconduct in a workplace would require an investigation, especially if that's going to lead to a termination without notice or a termination for cause. And that's really a cornerstone of those types of terminations. And Ljubica is going to talk about that shortly. Misconduct, disobedience, willful or neglect of duty, those are the trifecta of the reasons under the Employment Standards Act why an employee can be terminated without notice. And so I would expect an employer to complete a proper investigation into any of those reasons. Health and safety, I think it goes without saying what we've gone through in the past 2 years. There are plenty of reasons why health and safety issues may need to be investigated, and an employer may want to rely on their joint health and safety committee, or if they don't have a committee, they will have a health and safety rep. And so I would expect that person to be involved as well. Policy breaches and pay equity. If you're a federally regulated employer, the new rules around pay equity have come into force. It's important to keep that in mind. And any other policy breach. And that could be a breach of a code of conduct. It could be a breach of a vaccination policy, perhaps, that an employer has. Those would, could require investigation. And like I said, the length of the investigation, there is no minimum length. An investigation could be, I talked to one person, I talked to the manager, I assessed all of the evidence, I looked at some documents, those are the only people involved, and I have now decided these are, this is the facts, this is what happened. Or it could be very in-depth, if it's related to, workplace harassment or workplace violence. So those are just some of the reasons why an employer may want to or may have to investigate. So I wanted to address the keys to success and how, from our experience, how employers have, got through from the beginning to an end of a workplace investigation successfully. So first, I mentioned it before, a written policy on a workplace investigation, I think is key. And as it relates to harassment and violence in the workplace, it is legally mandatory to have such a policy. So a policy that you apply to workplace harassment or workplace violence could easily be applied to discrimination or other reasons why an employer might want to investigate. So having that written policy, updating the policy at least once a year, and having proof that the policy is being updated is important to do. But you can't just have a policy and you look at it once a year and you initial it and not do anything about it. The training on that policy is also important. Training, especially for managers and supervisors, because they will be the ones most likely who will, they have their fingers on the pulse of the operation, and they will probably be the first people who know whether an employer has to investigate. And if of the operation is aware that there should be an investigation started, especially, like I said, as it relates to harassment or violence, then the employer is deemed to know that such a complaint exists, and for harassment, it must be investigated. So training on the policy for managers, and of course training on for every employee. I don't think there's a downside to having every employee know exactly what the policy says. But you may want to cater the policy specific to managers so they know what to look for. Perhaps they can complete the investigation themselves if they're not involved. If the investigation does involve them, perhaps it needs to be escalated to a higher person or to HR if they exist in the operation. Initiating an investigation, and this is what I've just touched upon. As it relates to workplace harassment, workplace violence, as soon as the employer is aware that there may be workplace harassment or workplace violence, they must investigate. And that's what the law and the Occupational Health and Safety Act makes clear. And so, like I said, if a manager is aware, then an investigation must be started. So a lot of questions that we get from employers is, well, we never got a written complaint. We never got an email. We never received anything from an employee. So we didn't know that we had to investigate, or we didn't really know. Yeah, we heard some rumors. Someone came to us and asked if this person is okay, but we don't actually, we never received a complaint. So we didn't have to, like a written complaint, so we didn't have to investigate. As it relates to workplace harassment, workplace violence, but a lot of the other issues and the reasons why an employer may investigate, an employer does not have to have a written complaint in order to commence an investigation. If the employer is aware of it, or really probably I think a court would extend that and say if the employer ought to have been aware that there was harassment or there was violence in the workplace, they must investigate. So I tell employers all the time, they do not have to wait. They do not have to hold their head in the sand. If they think or if they believe that there is some sort of harassment, they can investigate. It may require some paid or unpaid suspensions. It may require, temporarily adjusting some of the job duties, for example, or schedules so that the investigation can take place. But an employer doesn't have to wait to initiate an investigation. And there can be some goodwill between employer and employee that can be, found there, especially where an employer is responsive. And if an employer says in a policy, we do not tolerate discrimination, and the employer is seen to investigate those issues as soon as they become aware of it, it's not only goodwill, but I think, if there is any potential litigation in the future, that would help for the employer, for their defense, for those matters. So an employer does not have to wait to initiate an investigation. Of course, if they do receive a written complaint, that is a very clear indication that an investigation should be started, a reasonable investigation in the circumstances. Like I said, it may be very short, it may be very detailed. The timing and timeliness of investigations. So as I've just alluded to, really there's no reason an employer should wait to commence an investigation. So it's important that if they're aware of it, that they start it right to inform the parties, and I'll get to that at the end of this slide, to inform the parties there is an investigation being started, and we will need your help to complete the investigation, just to put people on notice. The complainant and any potential witnesses and the alleged aggressor or respondent, as we would say in law, informing all of those people, as soon as you have to start an investigation. Hey, we're starting an investigation. Keep a copy of that letter. If it's an email, keep a copy of the email in the investigation folder. It's also important that the investigation is completed in a timely manner as well. And so an investigation, if it requires a lot of detail, perhaps, several weeks or several months is appropriate. Generally, if it relates to workplace harassment, workplace violence, or even discrimination, we would recommend that the investigation take place shortly and it be completed sooner rather than later, because those are issues that you don't really want kind of hanging in an operation. And also, if you've placed employees on a paid suspension, well, it makes sense to have the investigation started and completed in a timely manner. Any investigation has to be objective and impartial. And that means the people who are doing the investigating, they cannot be a part or they cannot be a potential witness to the investigation. And the person who is doing the investigation also shouldn't have authority over the people in the investigation itself, because those witnesses may cater their evidence to what they think their boss might want to say. So any person who's running an investigation, it should be objective, those people doing it, and it should be appropriate in the circumstances. And like I mentioned, informing all parties, that the investigation is started, that the investigation is finished, and also for the complainant, they should be made aware in general terms of what recourse was taken, if any, and generally what the outcome of the investigation was. And that even applies if it's in the pre-employment context, if it's a prospective employee who complained, well, they maybe didn't get enough accommodation, or they felt that someone was biased in some way. You could tell them, well, we've completed the investigation, this was our finding. And also we have retrained all of our managers on, implicit bias and accommodation in the pre-employment stage. So that's all possible. I do see two questions here, so I'm going to answer them before I get to my next slide. One of them has to do with the internal versus external. So the first question, does our firm offer training on workplace investigation for supervisors in HR? And definitely, we do. And we cater that training to the operation, to the specific needs of that operation. So we're happy to do that in person or virtually. We're happy to do it in person now that things are open a little bit more, but we can also do it virtually. And another question, how does this affect the obligation to investigate if harassment is between an employee and a third party? So a driver and a customer making a delivery. Does this require written notice? So that's a good question. So any good workplace harassment policy, it covers all harassment of any workers. And that may include a third party who's harassing, your employee. And so it's up to the employer to do, like I said, to do a complete, full, objective, impartial investigation. If they need to reach out to that customer, they should phone the customer or meet them and get their side of the story. They should get the employee side of the story. And the employer can still make a determination on whether harassment took place. There's a legal test to determine whether harassment took place. And if it engages a third party, so be it. The employer still has to protect that worker from harassment, whether it's someone inside the operation or outside. If you can't get cooperation of that third party, well, you can still proceed based on all of the evidence that you can collect. So if you can't collect any evidence from the third party, you don't have any credible evidence to rebut what your employee is saying. And as long as you find your employee credible, you may find that these are the facts and this is what took place. And then you can determine what recourse can be done. So it is the same obligation if it relates to someone internal to the business or external to the business. Just some extra tips before I give the floor to Ljubica to talk about termination for cause or termination without notice. Some other tips that I wanted to share are doing an investigation. So first, internal versus external. Sometimes it may be appropriate to hire an intern or to engage someone internally in the business, perhaps HR, to run the investigation. But it may not always be the most, the reasonable person or the most suitable person to do that investigation. And so sometimes an external party, such as it could be another law firm. It can't be your own lawyer. We're always happy to help our clients, but we are, hired and we are biased in favor of our clients. And so we are not, your lawyers cannot run an external investigation on behalf of the company. We can, of course, advise HR if they are running the investigation and they are making the final decision. But we are asked by other corporations and clients who are not our clients to run investigations. And we have relationships with other law firms who do run investigations. So I'm just a follow-up question from Curtis. He said, to confirm, written notice is not required of a complaint being made by an employee, but an employer just being aware that harassment took place is all that is required. And yes, that is true. We don't have to receive a written complaint from an employee or a customer. You may have a different policy related to customers, and if they have complaints about the business, you may deal with that in a certain way. That's not covered by the Occupational Health and Safety Act. But if an employee says, yeah, I got chewed out by a customer for doing what I was told to do, you do not have to receive a written complaint from that employee. You can investigate as soon as you receive the indication, or you hear something, even if it's hearsay. You hear from another person, oh, so and so said they really had a tough time with that client. You could choose to start that investigation, and if it's believable, you may be forced legally to commence an investigation into that harassment. And you're very welcome, Curtis. And back to my slide here. So another point I wanted to say for those internal investigators, and this is something that they teach in law school, especially about cross-examination. You have to put your theory to the person being investigated. If someone says, person A harassed person B, you have to ask, and produce all of the evidence that you have collected to person B, the person who's the alleged harasser in this example, and say, this is what person A has said. They said you said this, you sent this email, you ignored them, you were othering them, you made them a target, you told other people to harass them. So it's always important to put your theory and all of the evidence to that person being investigated. So you can clearly say, well, I'm going to suggest that you intentionally harassed this person because they ate your lunch or whatever the case may be. And I always tell investigators, don't be shy to put your theories or the evidence to the person being investigated. That's an important part of it. And it's important to note their body language and how they respond and take notes of all of that. And as I mentioned before, we do manager training as well. And we're happy to do that, like I said, virtually or in person for any, for a certain group, like I said, like managers, or even if it's a certain department, we're happy to cater that training to whoever needs it. So those are my extra tips on workplace investigations. There's just more of a high level overview, and that's what we wanted to do today, to give a high level overview and then some gems that you can take notes and take back to the operation, and keep in mind when those investigations take place. So I'm going to pass it over to Ljubica, who's going to talk about, oh, sorry, there are also some common mistakes. Ljubica, you don't mind if I just take a couple minutes to go over these?
I don't mind at all. I was going to put to you, I often get a question that is very specific, and that's, can an employer compel their own employee to participate in an investigation if they don't want to? Because you were speaking about compelling third parties to participate in an investigation and how that might not be possible, but is it possible to compel someone that works for you to do the same?
Yeah, an employee is, there's an employer and employee relationship there. And an employee, it's important that if they receive a reasonable direction from their employer, that they comply with it. Of course, you can't force an employee to explain everything in their mind. So if you're faced with a situation where it could be a respondent, it could be just another witness who is refusing to participate, that's a good opportunity to educate that person and why their evidence is so important, number one. Number two, it could be grounds for a finding of disobedience against that employee. But most importantly, as it relates to the investigation, it's the investigator's job to collect all available evidence. If that evidence is not able to be collected, the investigation still has to continue. So for example, if a respondent doesn't want to participate and they're evasive, or they keep canceling the meetings, or when they do sit down for meetings, they don't really fully participate, that is the evidence that has been collected, and a finding can still be made based on all of the evidence that's been collected. So when we face, uncooperative parties, like I said, we try to explain to them why their participation is so important, but ultimately the investigator, they can't really compel someone to tell them what's in their mind, but the investigation can still continue with or without that evidence. What are your thoughts on that, Ljubica?
So I've had a few investigations that involved uncooperative employees, and there are certain circumstances where you should not pursue collecting the information if you can't. So for example, if there is an employee who is on a leave of absence because of mental distress or something else that's related to, let's say, harassment in the workplace, which is the subject of your investigation, then if that participant, if that person does not want to participate and doing so would cause them additional distress, then I would say that it is a reasonable step to take to not investigate and interview that person if they're reluctant to do so. But to move on, like you said, just do what you can, collect all of the information that you can, pursue all the avenues that are available to you, rather than just stop the investigation because someone just is not cooperating.
Yeah, definitely. That's good points. So I've listed some common mistakes here. They are self-explanatory, and some of them I've mentioned already. You know, not putting the question, the most important question, avoiding your own. That's a common mistake. You know, not taking a complaint seriously. If you prejudge a complaint, you're completing the investigation in your head, and you're saying, well, we don't need to investigate that. Even if you believe that it's harassment or discrimination, especially those are the more common reasons an investigation is started. Take every complaint seriously, and like I said, if it shows that there is no that you make a finding, no, there was no harassment, no, there was no discrimination, so be it. But at a minimum, it can build that goodwill, and it shows that you have a policy and you're going to follow the policy as well. So if you have a statement that we do not tolerate harassment or discrimination, those investigations can help support that. Not documenting the process, it's important to take notes throughout, copious notes throughout any investigation. Reprisal, of course, it's technically against the Occupational Health and Safety Act to do anything against someone specifically because they brought a complaint of harassment. So it's important to keep that in mind, and to not take any negative steps against someone simply because they brought a complaint. Sometimes paid suspensions or a paid administrative leave helps in that way. The employee, perhaps their work is very important, and perhaps it's not appropriate to put them on a leave of absence. But to do whatever is appropriate in the circumstances, and keeping in mind you want to avoid reprisal. So on that note, I believe Ljubica, I'm going to hand it over to Ljubica to talk about termination without notice.
Thank you, Jonathan. Okay, so once you've completed the investigation, and you've heeded all of Jonathan's warnings, and you've done what you can as an employer to investigate, now you have some options depending on your findings. One of those options, I'm not going to list all of them, like Jonathan said, you can put somebody on a leave of absence, you can, there's disciplinary measures, between a warning and termination that you can take. And I'm going to talk about the highest form of discipline that you can take, which is to terminate an employee without giving them notice. In other words, for cause, something that is historically been called for cause termination. That's probably how you've heard it before. So when you complete your investigation and you have some finding of culpability, then you are probably asking yourself, can I terminate for cause or without notice? And the answer kind of depends on what the conduct was and to what extent that conduct is culpable. So let's just start from the basics. The starting point is always that employees are entitled to reasonable notice of termination. So if you are going to terminate someone's employment, you have to give them notice, and the amount of notice will depend on a variety of things, but the most important is whether or not they have a valid contract that states that they're only entitled to the minimum standards, or if they're entitled to common law notice. So there's a vast difference between the two if you do have a valid contract or if you don't, but that is a topic that we can take 2 hours discussing, and this is a topic about for cause or without notice termination. So I'm going to leave it at that. Just know that there is a range of notice that you might have to give if you are going to terminate someone without cause or with notice. So getting back to it, there are very why an employer might be able to terminate an employee without providing notice or pay in lieu of notice. In Ontario, which is the jurisdiction that we're going to focus on today, The Employment Standards Act tells us that there are only a handful of reasons why an employee can be terminated without being provided with notice. Some of the more significant ones are if it is a fixed term contract, so someone is maybe a seasonal employee or they're covering a mat leave and the contract is very specific as to a termination date. A frustration of contract. So if the person can no longer perform the core duty, then there is said to be a frustration of contract. That again is a topic of its own. Be a frustration of contract, and there is debate about that, but we're going to leave it at that. Job abandonment. So if somebody simply, stops coming into work without reason, without explanation, then there is a job, it's said to be a job abandonment. And then there are a handful of other very technical reasons that we're not going to go into today, but they're not many. And last but not least, and the one that's most highly debated, is if the employee is found to be guilty of willful misconduct, disobedience, or willful neglect of duty that is not trivial and not condoned by the employer. So those words are very important and very specific. Okay. Now, before we move on, Jonathan, can you take me to the next slide? I want the visual there. There we go. Let's make a distinction between what's commonly called for cause or cause and what the ESA, the Employment Standards Act, which is the legislation governing employer-employee relationships in Ontario, what it says is sufficient for termination with cause, right? So the common law, which is the judge-made law, says that the standard for terminating an employee without cause is that it must be serious and it must amount to a repudiation of the contract. In other words, the misconduct must evidence an intention to no longer be bound by the contract. Now, this standard is often used in jurisdictions that have employment standards legislation that is vague on what is cause, or they simply say that an employee may be terminated for cause. And so the judges who are interpreting that legislation will put this standard into play. Luckily, or maybe unluckily, in Ontario, we have a much narrower scope about what we can consider to be the standard for termination, and that has to be willful misconduct, disobedience, or willful neglect of duty that is not trivial and not condoned by the employer. Very important words, right? Like Jonathan said, the trifecta of termination without giving notice. I'll give you an example. In one case called Osterbach and FAG Aerospace Inc., a production employee was disciplined 4 times for various infractions according to the employer's progressive discipline policy. The infractions included lateness, taking extended breaks, several trivial performance issues, and even though the judge found that the employee's persistent misconduct amounted to of casual and careless conduct, those are the words of the judge, casual and careless conduct that was inconsistent with the continuation of his employment at common law, the behavior did not rise to the level of willful misconduct, disobedience, or willful neglect of duty. That is not trivial and it wasn't condoned. The employee was reckless, sure, and without regard for the consequences of his behavior, but what he did was not enough to land him cause termination in Ontario. So the end result was that the employee was entitled to reasonable notice of his termination. There was not enough to fire him for cause.
Ljubica, we got a question from one of the participants. So I wanted to ask you just before we get into the other cases. So there's a question. So is a monetary settlement required as part of a termination without notice?
So it depends on what is meant by the word settlement, because there are a few things that could mean. It could mean the reasonable notice or pay in lieu of notice, which employees are entitled to, which, like I said, could be anywhere from approximately 1 week for every year worked, with the maximum being 8 weeks, or 1
Hold on,
month.
sorry, this is a termination without notice.
Oh, for a termination.
Yeah, so, or what we would call for cause. Do you have to pay employees when you terminate for cause? That's the other way.
Right, okay, so when you terminate for cause, as in under the common law, if you fall within the larger circle, but aren't quite within the ESA cause, then yes, you have to pay termination pay. Right, so you could have a for cause termination, but if it doesn't fit in the narrow scope of the ESA cause, which is the willful misconduct, disobedience, willful neglect of duty, then yes, you have to pay the reasonable termination pay. And again, that depends. That range depends on whether you have a contract, et cetera, et cetera.
Yeah, and I want to underline that point because it's it might be concerning to some employers who are hearing it. And so what it is, what we're trying to say here is every termination without notice that an employer does, it needs to fall within this ESA cause section. It must. If you have a termination that, so it is serious misconduct, but perhaps you haven't shown that the employee, you didn't find the employee guilty of willful misconduct, or you didn't find the employee guilty of willful neglect of duty. There may be some cases where you have to pay that employee.
So like casual or careless conduct, as in the FAG case, right? Casual or careless conduct was not enough to land the employee ESA cause.
Right, but overall, let's say if there, and this applies for everything that we're talking about. If an employee is found guilty of willful misconduct, everything that is willful misconduct will count as common law cause. It will count as cause 100% of the time. So if you do find an employee guilty of willful misconduct, find them guilty of willful misconduct, and you complete an investigation, and you say, yes, this is what happened, employee was responsible for A, B, C, we find it not just misconduct, we find it to be willful misconduct, there is no settlement that has to be given to that employee, because that employee is not entitled to any notice of termination, period. Okay, but that is if we can get their conduct within this smaller circle of ESA cause, those very specific reasons. So that's a long-winded question for John, but so generally, no, employees who are terminated without notice, they aren't entitled to a settlement, but an employer could choose to provide a settlement to that, or an offer to that employee if they wanted to, but it is not necessary, and the employee would have very limited entitlement to any money, because they were found guilty of disobedience or guilty of willful neglect of duty.
Absolutely. So some of the best ways to illustrate what might fall within that narrow range is to look at some of the case law. And I tried to cherry pick some of the really good ones. As you can see, there are amazing examples of cases where the employer was unsuccessful, but there are fewer ones where the employer was successful at terminating with cause or without notice, right? So it's a little bit tricky. I feel like the scales are tipped in the employee's favor for the most part in Ontario, just because of that narrow scope of what the conduct has to fall into for there to be a termination with cause / without notice. So let's just look at the cases. The first one is a case called Huxco. It's hard for me to pronounce that one, Huxco, and A.O. Smith Enterprises. A recent case, 2020. The plaintiff, Mr. Huxco, was 60 years old when his employment was terminated for cause. At the time of his dismissal, he worked for A.O. Enterprises and its predecessor for approximately 20 years. In 2017, he was subject to a workplace harassment complaint. And the complaint, which was made by a female colleague, detailed 4 separate incidents in which Mr. Huxco made inappropriate comments and or gestures to the complainant. The employer launched an investigation, as they are mandated to do. And ultimately, they determined that while not all of the allegations could be substantiated, they did find that there was some inappropriate comments made by Mr. Huxco. Following the investigation, Mr. Huxco was advised that he would be required to participate in training, as well as to apologize to the complainant. After seeking legal advice, Mr. Huxco agreed that he would undergo the training, but he refused to apologize to the complainant. He said that what he said was only in jest, and he outright refused an apology. The employer subsequently suspended and then terminated Mr. Huxco for just cause, claiming an irreparable breakdown in the employment relationship. And that's when Mr. Huxco sued for wrongful dismissal. The court in this case found that although much of the trial dealt with his conduct that amounted to sexual harassment, the actual reason he was terminated was not the inappropriate conduct, but rather his refusal to apologize to the complainant. So was that the refusal to apologize enough? Did that rise to the level of willful misconduct? And the court in this case decided that it did not. The employer did not have enough just cause to terminate the employment relationship. And so the employer in the end ended up having to provide the employee with reasonable pay in lieu of notice. Okay. The next case, which I really like, is very recent, and it highlights a lot of different things that Jonathan has spoken about with regards to investigations and the appropriate way to do it. So in this case, this was a female fire captain and an administrative assistant to the chief for a volunteer fire department, was terminated without cause, terminated for cause, my apologies, because of rumors in the workplace that she, among other things, sent nude photos of herself to various male firefighters, that she was having affairs with various firefighters, including the chief, that she was texting exclusively with a male firefighter, that she was causing other firefighters to quit, that she caused morale problems in the workplace, among everybody, that there was other departments that were spreading these rumors and were saying the same things about her. And the list goes on. But in the end, what happened is that at trial, it came out that the CAO, there was a recording of the CAO to the council advising why she should be terminated for cause, and all of this laundry list of rumors came out in the open. So it turned out that none of these rumors were factually correct, or they weren't corroborated. The investigation turned out to be a sham, and the CAO had simply had passing conversations with some of the employees who were either passing along rumors or had heard rumors about this employee. But importantly, the CAO didn't actually investigate or interview the people who were involved in the misconduct. So he didn't interview the people that she was supposedly sending nude photos of herself to, didn't interview anybody with regards to the affairs, et cetera, et cetera. And he didn't interview Miss McGraw specifically, the person who these rumors were about. And without any such evidence, he said she is a disruption here and she must be terminated for all of these reasons. We're terminating her with cause and without providing her notice or pay in lieu of notice. And in a very scathing decision, the court awarded Miss McGraw 6 months of pay in lieu of notice, moral damages of $75,000, discrimination damages of $35,000, defamation damages, $20,000, and punitive damages of $60,000. All up, she received close to $200,000, not including the pay in lieu of notice. So it was important here too that none of her male counterparts were treated the same way. None of them got disciplined in any way or terminated. And yet she, who you know, it takes two to tango, they say, right? She being the female employee who was supposedly doing all these things, got the brunt of it. So I think it's important there to highlight that the investigation portion of it, even though the CAO said, yes, I've done an investigation, the investigation simply consisted of a few conversations that he had had, passing conversation, not as part of a global investigation into what had happened. And so the employer was found culpable, and they owed a lot of money in the end.
Right, plus the legal costs, which that decision hasn't come out yet, but
Yeah.
if they can't agree, there could easily be 20, 30, 40,000 of legal fees that are owed to Ms. McGraw.
Absolutely, absolutely. So let's move on to successful terminations without notice, or successful for-cause terminations. The first one, again, is a very recent one, Gorak and Greater Barrie Chamber of Commerce. Ms. Gorak was a 17-year executive director of the Chamber of Commerce, and she was terminated for cause. It was found that in her role as an executive director, she was a fiduciary employee, meaning that it was crucial that she acted with honesty and integrity in discharging her duties. So the cause conduct, the for-cause conduct in this case, was that Ms. McGraw, over a period of time, had given herself an unauthorized raise of 3%. She improperly awarded service contracts to family members. She improperly used business credit cards for personal expenditure. She authorized herself to take pay in lieu of time off, amounting to approximately $8,000 in pay. She altered bank documents to save on time, and there was a few other sort of not as significant infractions. So the judge in this case found that none of the individual acts would be sufficient to support a for-cause termination, or a termination without giving notice, but taken together, they rendered her unfit for the job and irreparably damaged the employment relationship. So this was willful neglect of duty, willful disobedience. So this decision, I think, is important. It raises a lot of different considerations when assessing whether or not an employee's conduct might amount to a for-cause termination. So, for example, even if no particular instance of misconduct amounts to just cause, like in this case, it's possible for multiple instances taken as a course of conduct to rise to that level. Right. The other thing is about this being a fiduciary employee, which is someone with a higher standard, held to a higher standard because of their role within the company. Right. So if you have an employee with fiduciary responsibility, then you may have a for-cause termination in an instance where you might not with some lower level employees. All right, so the last one is a 1992. Like I said, it was slim pickings out there for with cause terminations. But this is, I think, a good one because it is something that employers ask me about all the time, and it has to do with vacation time. So in this case, the plaintiff was employed as a production manager with a supervisory role, and he managed about 12 employees at his workplace. He wanted to take a leave of absence for 1 week to go to Germany on vacation, but he was told by his supervisor, who he had to get permission from, that because of other absences at the time, other employees taking vacation, the workload, the plaintiff couldn't be spared, right? And he needed to come to work. And the plaintiff's supervisor specifically made it clear that should he act in defiance of the specific refusal of the leave of absence, then he would be deemed to have resigned, right? So there was some indication that this employee was going to take the leave of absence, whether he was permitted to do so or not. And the employer was straightforward and said, if you do that, you will be terminated, or you will have been taken to resign from your position. And the plaintiff took the time off anyway. And on his return from Germany, he was presented with a letter of resignation, which he refused to sign. And in the end, the employee was actually terminated with cause. The employee brought an action for damages for wrongful dismissal, saying that was not enough for a with cause or with cause termination / without providing notice or paying lieu of notice. The judge in this case found that the conduct of the plaintiff was tantamount to tendering his resignation. So if the plaintiff didn't resign, then the defendant had shown just cause for dismissal on a balance of probability. So not only was the plaintiff's conduct an act of willful disobedience, but it was, in the judge's word, a flagrant thumbing of the nose to the employer, right? So I think that it's important here, because I don't want this to be misconstrued, this case. I think it's important to talk about the reason why this employee took the leave of absence, which was just to go on vacation, okay? There was nothing else to it other than I planned a vacation. I already booked my time or my plane ticket. My family's ready to go, so I'm going, whether you like it or not. Now, had the case been flipped and this employee was going to Germany to take care of an ailing family member, or to get a surgery that they really needed, or something else, or another ground that is protected under the Human Rights Code in Ontario, then the employer would not have been justified in terminating this employee, period, for cause or without cause, because there would have been a valid need for an accommodation of this employee. Okay, again, this is a huge topic that we do actually have another webinar on, right? But it's important. I don't want anyone to take the wrong things away from this case. I wanted to highlight it because it is often put to me, can I do this with this employee who just isn't, complying? Yes, you can, but you have to inquire as to the reasons why they are taking their vacation.
Yeah, and just like you said, if you warn the employee that what you are doing will amount to willful misconduct or disobedience, if you tell them that, it will be a lot easier to prove that the act was willful. Of course, you have to prove willful misconduct, not just regular misconduct. It's willful misconduct.
And what if it was misconduct, but the employer didn't at the outset say, if you go, don't expect your job? And what if the employer tried to terminate, let's say 6 months later, after the employee came back from Germany and said, oh, well, we're terminating you because of that time you did that thing? Would that be the employer, would they be condoning that act?
Yeah, I mean, with that amount of time passing, it could be, and that's like you said before. Even if they can prove willful misconduct, it cannot be trivial, and it cannot be already condoned by the employer. So if there's any misconduct, it should be investigated and dealt with, immediately.
Yeah,
I am aware of the time, but I know you have a little bit more to say, Ljubica. So I'll let you say with this one.
So I just want to wrap up here in terms of how to implement a termination for cause or without giving notice. The investigation portion of it is very important. Very seldom there's a time where one set of circumstances or one act will be enough to terminate an employee. And that might be, I don't know, let's say the employee brings a gun to work and threatens coworkers. That might be a singular act that requires termination without cause, without notice, with cause, without notice, right? Immediate termination on the spot. However, that's not usually the case. Usually there is misconduct or willful disobedience or neglect of duty that crops up over time. There might be complaints about something. So the investigation process is really important. The substantive part sometimes is not as important as the way that you conduct the investigation. If you conduct the investigation improperly, sometimes even if there is maybe a misstep at the end about how you apply it, that's still you'll still come out better if you do an investigation, is what I'm trying to say. So really important. Start and finish the investigation. And then if you do find that the conduct falls within that small scope of willful misconduct, disobedience, willful neglect of duty that you haven't condoned, right? Then you can complete the termination by providing the employee a detailed letter stating why you are terminating them, giving them, the specifics, telling them about the investigation. And then in some instances, it's appropriate to offer a release agreement, but not always. A release can be a blessing or a curse. In some instances, if you offer a release agreement, you are giving the employee reason to think that you're doing something illegal, and so you are requiring a release of them, asking you of your obligations as an employer to provide notice or pay in lieu of notice. And so they might take that release to a lawyer, and unwittingly you will have sent that employee into a situation where an employee or an employee side lawyer is telling them that they have a case against you and they should not sign this agreement, and now you're faced with a claim for termination notice. On the other side, if the employee does sign it freely, willingly, after they have consulted with a lawyer, then the release can act as a shield to protect an employer from these kinds of demands or suits, right? So contextually, there is a time and a place for them, but it's not always. An employer thinks that it's always a good idea to have a release or to ask for a release, but if you don't get that release signed, then it might not be a good idea to do that. And I think that will conclude what I have to say, and maybe we'll move on to some questions. If we have time.
We've answered all the questions that have come through in the chat and the question and answer. So if any of the guests here want to submit any other questions, feel free now. I do see it's past our time that we asked you to hold in your calendar, so we appreciate you joining us here today. But of course, if you have any other questions that you might want to ask us over email, we're happy to answer those, or to set up a time to talk with us. We're always happy to do that. So I don't see any other questions coming in, but we're very happy to have done this presentation today, and we have others that are happening later this month and next month, just on other topics, just as kind of brief refreshers and providing some gems to employers to keep in mind when they're running their businesses. So on that note, I'll thank everyone for attending today, and please reach out to us if you have any other questions, and I hope you have a great rest of the week.
Thank you, everyone. Have a great rest of your day.
Bye-bye.